Welcome to Better HR in 10 Minutes, where we take a question for HR and in 10 minutes or less, we discuss it from the point of view of a trainer and an employment law attorney. I'm the trainer, I'm Rodney Klein.
And I'm the employment attorney. I'm Sarah Glasser.
Sarah, did you need to give your disclaimer today?
Yeah, I forgot to give it last week, but
It's
y'all remember.
retroactive
Yes, this one. This disclaimer applies for this one and last week's.
and next week's too.
Yes, and y'all forget them too. Y'all, I'm a lawyer, but this is not legal advice. It's just me and Rodney having fun.
Fair
Most.
enough. Okay, well, like the last video we did, we talked about discrimination based on gender identity and sexual orientation and the Bostock decision. But, that's like what, half the story? The other half of the story are the practical implications of this in the workplace, because there are quite a few practical implications, and there's not a lot of agreement as to what the answers are for those. So, Sarah, why don't you talk a little bit about what some of those practical implications are?
Hmm. Yeah, okay. So huge topic. So we're going to talk about it like high level and if we didn't say what you think we were going to say, we're going to say that in the next one. Um so Bostock says it's a violation of Title VII if you discriminate against someone based on their sex, and sex includes or can be defined as including someone's sexual orientation and gender identity. Okay, we get that. And when we're talking about discrimination, we're usually talking about some type of employment action, but a type of discrimination can also be harassment. And one of the things that I'm getting more and more phone calls about these days are questions about issues that are coming up in the workplace that have the potential to create claims or complaints of harassment that fall under this kind of Bostock type umbrella. So things like a person having a preferred set of pronouns and a colleague who is refusing to use their preferred pronouns or refusing to use the preferred name of one of the colleagues, or if you have an employee who is transitioning and you've got other employees in the workplace who are uncomfortable with that or don't want you to allow that employee to use the bathroom. So bathroom stuff, pronoun stuff. What am I missing?
Just names, pronouns, and restrooms, I think, are probably the big three, right?
Okay.
I think
Yeah.
that's the ones that, and the reason I think we're talking about these is because in Bostock, the Supreme Court was really clear that this is protected, but they also said, yeah, we're not really talking about those other issues right now. And it's cool to be a Supreme Court justice. You don't have to talk about things you don't want to talk about. And they decided they just didn't want to talk about that, which means these are not necessarily settled questions legally.
Yeah. So they're settled in some places. There
Right.
there are courts around the country who have heard cases where someone filed a harassment claim based on harassment based on their sexual orientation or their gender identity. And there are
Mhm.
courts that have heard that, and there are written decisions that address that. And so it's not that no one has ever heard it, but we do not have a an overarching set of precedent that says if you have an employee who refuses to use someone's pronouns, that is definitely discrimination under Title VII,
Right.
harassment under Title VII.
I think
Uh,
sometimes what people think is, if I get this wrong, I think that people say, well, because the Supreme Court didn't address those issues, then anything goes. It's the Wild West. I can do whatever I want. And it's like, no, I think that means you have to fall back on case law, harassment case law, to try to piece together what you ought to be doing. And
yes. And I don't want to interrupt you, but to those people, I say, do you want to be the test case? Okay, go on, go on.
no, that says it all.
I mean, really though, here's the thing is okay, just because we don't have a Supreme Court case that says, says X or says Y, that does not mean that you will not have a charge of discrimination filed against you based on those allegations, or that a plaintiff's attorney will not agree to take on that employee and represent them in a lawsuit against you. And so there are putting aside things like respect and having a workplace that is working well and everyone is getting along and working together. Putting aside all of that stuff, y'all, you don't want to get sued, and 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 you don't want to have all of the things that come along with getting sued, such as having to hire an attorney, having to take away time from your actual business operations to defend something like this. So, even if we don't have settled law on the issue, my strong recommendation to everyone who I talk to who calls me and asks me these questions is try to find a way to get your employees to get along if you've got someone who is not getting along for any reason.
Yeah, and I think this kind of goes in conjunction with harassment guidelines because there's not like a big list of things you can and cannot do. It's not listed in the law. There's just really pretty much two things that makes behavior illegal. One is that it be connected to a protected basis, and the other is that it create a hostile and intimidating work environment. So kind of the measure, the judge of what's going on in your work situation is whether or not that behavior, whatever that behavior is, whether it's starting to impact that employee's ability to get their job done, whether it starts creating a hostile work environment. Now that's legal stuff. So where do you go to get legal ideas? You go to
Without being
attorneys. Yeah.
self-serving,
So
you
if
go
you
to
so
your
because these
lawyer.
things are not necessarily all together settled, the Supreme Court has not ruled on these, and maybe there's not necessarily agreement in many of the courts. This is a real reason to make sure that you're staying in compliance with the law.
Yeah, absolutely. Couldn't have put it better myself.
I think you did.
Very well. Well, y'all, it was fun. Hopefully you learned something and we were helpful to you.
Yes.
See you next time.